Okay, abusua ena no ada ye ba ebe be breaking news bi mamo. Eye High Court, eye the final ruling on Kpandai constituency. Sorry. Matthew Nyandam NPP eye candidate. Or walk Kpandai. I just say timer final ruling from the Supreme Court no a go in favor of him no. Abusua sisi no latest update on that final ruling no. I want sense bebre aba sisi a person customer mind back during a Supreme Court in the final ruling and sema Matthew Nyandam editu na ye ba ye de akaba beto so mama yanko na yanko ti nsema Matthew Nyandam editu during final ruling on Kpandai rerun of elections are never because mama yanko na yanko ti ye ba na ye de akato am so.
Supreme Court has spoken emphatically that the decision of the Tamale High Court was made without jurisdiction, and so the court has quashed it and is hereby quashed. So Honorable Nyandam still remains the MP of the people of Kpandai. So we call it still maintained.
To thank my lawyers and also use this opportunity to thank the Supreme Court judges for the ruling, because it's clear that the people wanted to change the will of the people of Kpandai, but the Supreme Court has affirmed the will of the people, and I'm most grateful to them. I also want to thank the party from the head to the bottom, that is national, regional, and the constituency, for the support they've given me. And the people of Kpandai, I'm sure that when you are in Kpandai today, you will see the joy of the people.
Now, as
Okay, abusua Matthew Nyandam ena echese yetenenka during a Supreme Court final ruling and ena no ada yeba eba be breaki e de mamo Supreme Court mislead a Matthew Nyandam and mislead a court and whole punishment one sense my lawyer Martin Pebu e de betu e de my na ene NDC legal team Eden Sembi Ababetuda, Dr. Rashid Tanku. Abusuane Sema or the Ababetudano. NPP fake gazetted letter and as a document. Abusuane ya expose Matthew Nyandam and NPP. Judges no answer to me sa NPP fake document. Omo discover NDC legal team no aboa judges amomo to me discover sa fake and as illegal gazetted document ya abusuya sisi ano NPP for and as Martin Nyandam na so ayehie papa abusuya Dr. Rashid Tanku a police some evidence be with fact mama yanko na yanko ti ensema Dr. Rashid Tanku erituja efa and some ekokoso any illegal gazetted documenta NPP for ediko bri judges no any so and nun to a far so ma Supreme Court a ruling in favor of NPP. Abusuya na NDC for the almost say omonti ase ne NTSH. Amomi yanko na yanko ti on subscribe like na share ma afofron so ensa into me and don't forget to click on the notification bell so that there are any updates we ever dropping on also onsa able to me akabi Gossip Politics TV so madam
so what do you say?
Well, let me say good morning to you and then my co-panelists and the cherished viewers across the globe. Council, we accept the decision of the Supreme Court. We are a law-abiding political party, but we disagree the ruling. We disagree with the ruling totally. Total disagree. And we are waiting for the reasoning behind of their ruling on the 6th of February. They indicated it to come out on the 6th of February. Then we advise ourselves appropriately. Because if you look at, let's set the business straightforward. The Supreme Court doesn't have jurisdiction over the substance of the matter. If you look at the Enabling Act, the PNDC law 284, that talks of election petition. Under Article 99(1) of the Constitution, it is only the High Court that goes into election petition matter. Supreme Court doesn't deal with that.
Supreme Court is a supervisor of the realm.
But it doesn't go into
if something goes to the High Court or any other court, the Supreme Court has power to review it.
We agreed. But we are saying that when it comes to the substance of the matter, going to the nitty-gritty of election petition, under Article 99(1), it is the High Court. That one there I defer that one to you. Now, when you look at the matter critically, what the Supreme Court did was based on technical issue of Gazette, not the substance in itself. If you go and look at the ruling of the High Court, page 151, it's very clear that the election was properly rigged. The judge makes references to those things. And I have the ruling, I can make it available for you, for them to tease out that portion where the judge, the learned judge, mention of a polling station recording 1,422 votes. Council, you know that we don't have a polling station like that in Ghana. That has a voter population of 1,000. The highest we have is 750. 750. If you have more than 750, it will split into two. But this is a kind of voting that occurred in Kpandai constituency. Now, why are we battling the issue with Gazette? And that is
so for the Gazette, you mentioned the matter of, is it overvoting?
That is what is pointing out.
Okay, that there is a polling station.
A polling station.
Which has less than 1,000, but there was recorded over 1,000 votes.
1,000, yes.
That's, what do you make of what Dr. Osankwaphong says? In that case, hold that the elections have been, damaged in this particular place. So go and correct it, rather than say go and do a whole new election.
That was not the only one. Don't forget, Honorable Nyindam won about 3,000 votes. In two polling stations, another polling station recorded 1,200 votes. So that means in two polling stations, you have scored almost 2,000 votes. So what are you talking about?
So impeach those two.
So we are saying that is why the judge was looking at it. And we said that when we sent our reliefs to the High Court, we sent 14 reliefs. Mm-hmm. And then at the case management, this 14 was consolidated, set out for trial. 3 issues were set down for trial. And one of them was we were asking for the nullification of the entire results because of the infraction of Regulation 37 and 39 of CI 127 by the electoral officer and the presiding officer, the returning officer of the constituency. We gave copious evidence and tendered evidence to show that they violated these enabling 2 regulations of the CI 127. And we convinced the judge to believe that, yes, they didn't do the right thing. They violated those 2 regulations. And those 2 regulations borders on the collation of results of parliamentary election. And it was very clear about it. And so when we did all this cross-examination with them in order to, the ruling came out on 24th November. And it was very clear. I am not surprised my colleague's opponent ran to the Supreme Court because they know if they had gone through the process of appeal, going to appeal court, they were going to suffer another defeat over there. Because I don't know what kind of new evidence they were going to adduce based on what we had cross-examined them in the electoral officer. So they decided to go on this tangent, of which we are saying we will go into it. And when we file our affidavit in opposition to their application at the Supreme Court, we're citing them for fraud, the 2 of them. And I'll give you the elements of fraud that we are going to pursue on that.
In your main petition in the Tamale High Court, you were clear about a particular number of polling stations that have been affected, correct?
I said we have set out 14
I understand
and one
that.
of the lists was what we are talking about.
I understand that.
About the number of polling stations.
How many of them?
We had set out about 51 of them.
41.
No, 41 of them, the polling stations.
Right.
Indicating that they should look at this 41. Because we're making reference to the Regulation 37 and 39 of the
The judge was faulted by many members of the public, including some lawyers, that what was before you was to determine 41 polling stations where the voting was allegedly rigged.
Council,
so why do you come to a conclusion by saying that let's go have a rerun, I've annulled the whole thing, go have a rerun in the whole constituency?
Council, at case management, these 14 reliefs, when we consolidated it into the 3 issues set down for trial, one of the reliefs among the 3 was the nullification of the entire results of the 152 based on the infractions therein. So it wasn't that we were asking the judge to look at only the 41, but we're asking for the judge, which is the third issue set down for trial. The last one, in fact, I wanted to read that one, the 3 issues for trial.
All right.
And the last one was...
You're going to the merits already.
Yes, and that's why we're saying. So it wasn't only that we were going in for only the 41, but we were also asking the judge to nullify the entire thing because it violating Regulation 37 and 39 of CI 127.
You're right, there was a relief like that. Now let me go to, what do you make of this? This is a point you concede and you can't do anything about because the facts are against you.
You see, counsel, my sister has made our work easier. I told you that we have filed in our affidavit in opposition to the application at the Supreme Court. We're citing them for fraud. The Electoral Commission and the NPP. She has made our work easier. And I'm very happy with her presentation on the element of fraud.
Too late.
Not too late. We are taking that leg. In fact, we are advising our candidate to take that matter up with the CID, to go into the matter of fraud. Look, perjury is a serious matter. They filed on the 6th of January, 2025, a motion with a supplementary affidavit on 21st January and attached this 6th January Gazette that my sister is trying to run away from. It is the NPP that brought the 6th January Gazette and swore an affidavit that this Gazette was a proper Gazette of the 2024 7th January election. And in that Gazette that they filed at the Tamale High Court, included Kpandai. I have it here. I can give all their this. In fact, their motion, their supplementary affidavit, and then the exhibit of the 6th January. They did it. They swore an affidavit. And you know, when you swear an affidavit and you lie before a court, it's perjury. And these people are, otherwise, this thing that is happening, counsel, we have to take it seriously. Because false representation.
When they filed, they didn't ask you guys to withdraw.
No,
I'm didn't wait for the court to rule and say, in fact, what they filed was accurate. You decided that, oh, what you have seen looks like that's the correct thing. So you withdrew.
You see, when we filed on 23rd, at that time, Electoral Commission was flip-busting. They didn't want to come out. We know we're forcing them because we conducted the election on the 7th. Up to 20th, and you are not gazetted. 21st, there was no gazette. 22nd, there was no gazette. I would say, what is happening to this EC? We have to go to court and force them out from their slumber. So that was the reason why we filed on the 23rd. And so when we filed on the 23rd, quickly, you know that this Electoral Commission, I always describe it as crooked Electoral Commission. Quickly, NPP got hold of a gazette dating 6th January 2025. Where did they get it from? Where did they procure that gazette? That is a question we are going to go in. That is the root cause of the fraud that we are talking of. They fraudulently procured this gazette, attach it to their motion and affidavit, trying to get the judge to dismiss our application.
If you have a document,
yes,
and you believe in that document,
yes,
at the time you had it,
yes,
that will not be fraud.
That is why I'm saying that. But when it turned out that the document was procured fraudulently, that is the element of fraud will arise.
The document that you then relied
on, because the EC themselves was a party to the matter. The EC was silent about the issue when we withdrew the matter and filed on 25th because we believe them.
But the substantive point is that,
yes,
in the end, you concede that you were completely out of time in filing and also paying for security for cost. And the law is plain that there will not be extension if you miss the time. So as the evidence go by the Gazette notification that we have seen, which is the only one available, which the Supreme Court has relied on once and then again the second time, you got it wrong.
No, counsel, you see, what happened was this. The 23rd one, of which they came on the 6th January to file. I'm talking of their motion that they filed in dismissal of 2013 was filed on the 6th January. Interestingly enough, the Gazette that they used was also on 6th January. So where did they get it? The coincidence was so clear. They filed on
you have canvassed that point.
So I'm saying that, yes, we agreed that our 23rd had a problem, so we withdrew that one. And there was a cost against 7,000, so we had to pay for withdrawing that matter. So when we filed the 25th one, then 27, we paid the cost, the necessary, this is based on Section 18 of
those two
Act.
Instances.
Yes.
Those 2 instances, you were out of time.
We are not out because we're relying on the 6th January Gazette, which they brought, and the court accepted it, and based on that, we filed. So we're within 19 days. That was our point. But because we based on what they had filed before the court.
Right. So my last question I put to you is based on the Gazette that we are now using. You admit that you got it wrong.
No, you see, we are still not agreeing because that is why we are citing the EC. Why would the EC come out with 2 gazettes? Because they, according to the NPP, when they brought it, they said they got the gazette from the Electoral Commission.
The EC says there's always been 1 gazette.
So they must come and answer the question before the CID.
Okay.
Because that one.
So you agree that this Supreme Court panel, they had no option on the basis of these facts to hold the way they held, correct?
That is why we want to wait on the 6th of February to see the reasoning behind it. And then because in open court, lead counsel for the applicant, my good friend Gary Nimako, when he made his submission and sat down, the president of the panel asked him question on the issue of the fraud. The first interested party raised issue of fraud about that matter. Why is it that he didn't address the court about the issue of the fraud they raised in the affidavit? And I'm happy my sister added to that. He rose up and said it was a genuine mistake. How can this be a mistake? When you make false representation before a court, expecting to get a ruling out of it, and then the ruling went against you subsequently because one went to case management and all that, at the Supreme Court, you now say it's a genuine mistake.
Right.
So that matter must be looked at critically.
Let's proceed, but you would recognize that for the party to say that something was a genuine mistake, it would negate your attempt to raise fraud. Or quickly, let's hear from you before I move.
Okay, so...
A quick one. We filed particulars of fraud. It is here. I can send them to you.
Okay.
My sister, you see...
Wait.
Look, look at it. It's here. We file it on. Look at it on 6th January 2025. One way referring to their application and other thing. And so we attach all this in. And that one they are referring to the Republic versus High Court Commercial Division expert, the one that we're dealing with. So we file particulars of fraud, and that is why we are saying that the issue is not that.
What you are referring to is a certiorari application.
Yes, that's why we are saying that.
Particularized fraud.
No, the way you see the certiorari application, they clothe it in the form of judicial review. That's how they
a certiorari is a
of course. So that was the way they've sent it and other thing. We were looking at why would these people did false representation at the Tamil High Court, expecting that they got favorable ruling. It didn't go their way. They abandoned the process of which they applied for the appeal. But you see, something must be clear here. Counsel, and I'm happy Professor Kwapong made mention of that. The Electoral Commission was a party to this matter.
Yes.
At the case management, the Electoral Commission was seated, they were mute, they didn't say anything about the 6th January Gazette. When the NPP was flouting all over the place and banding it around, and that thing, the Electoral Commission Council was seated when we were setting down issues for trial.
It's not to be objected to at the case management. It's to be objected to when the cross-examination is going on.
And that is why we say that, look, they filed their written address to the court on the 14th of November 2025. And in their written address, they didn't make any statement about Gazette notification or audited. The Electoral Commission was silent about it.
He
That's
who
what we're
alleges
saying.
must prove. So if you allege, did you prove it?
Of course, why do we have to allege? Because the matter traveled on and nobody raised issue about Gazette.
Okay.
And cross-examination and all that. And when they were filing their written address by their
I get your point.
Yes, so,
okay, so let's move on. We need to move on from here.
Okay, abusuya we ne ensema ekoso ewo political highway so eye NDC legal team na yete eye Dr. Rashid Tanku ne nkase odisa ensem no ede tudwa ede amaye sa eye obisa ekwan ben so na sa on the 6th of January NPP fonya sa gazetted document no. That means NPP and EC no omo akabum ena omo katakata nyoma bi so abusia we ne ensem ekose beda mase some jepene kokuti za ensem we ede mai aha gossip politics TV so and don't forget to click on the notification bell so that any update be able drop no onso onsa ebe to me akabi beda mase